took a very strong position, arrived in Gujarat between March 19th and 22nd, and two reports that the NHRC brought out. First is interim report in April 1st, 2002, and then the final report in July 2002 were fundamental. And anybody who's interested in looking at the relative successes that we've had, relative failures that we might still encounter related to the Gujarat cases, need to look at this report very carefully. It was a very important report. It remained a very important report because it did 5 or 6 things, this NHRC report. This NHRC report, first of all, being headed by a former Chief Justice, articulated the complete state complicity and hand in the violence that broke out in 19 of Gujarat's 25 districts following the Godhra train burning incident on 27 February 2002. It was unequivocal in stating that there was a state hand in the spread of violence. It was unequivocal in expressing that the state was misconstructing figures about the people who had died and injured. NHRC's report spoke sharply about the discrimination displayed by the government and Modi when they decided to give 2 lakhs to the Godhra victims and 1 lakh to the post-Godhra victims. Did not want to actually have the cabinet and the chief minister investigated in terms of the inquiry commission, etc. Commented sharply on the relief and rehabilitation measures, and also commented on the fact that partisan public prosecutors were being appointed by the state. Now, when we are talking about rule of law and minority rights, in India, like in all the Anglo-Saxon countries, all the countries that have followed an Anglo-Saxon pattern of jurisprudence, unlike the European countries, the state is a prosecutor. Whenever a crime happens, the state is a prosecutor. Individually, you can have recourse to a private complaint, go to a magistrate, etc. But the state remains the main prosecutor of crimes. And it is the state that has compromised and failed in the prosecution of these crimes. So if the state, instead of appointing independent persons of integrity as prosecutors to prosecute crimes against the minorities, actually appoints, like Gujarat state did, persons belonging to the RSS, VHP and Bajrang Dal as prosecutors who happen to be lawyers, then you're not likely to get justice. And this is what the NHRC commented upon. NHRC report came out, like I said, interim report in April and final report in May. Moment the interim report came out, we went to the Supreme Court. And when I say we, I'm saying Citizens for Justice and Peace. Our group went to the Supreme Court. And our prayer to the Supreme Court was, hand over the critical cases related to Gujarat, 9 or 10 cases, to the CBI, to an independent agency, not the Gujarat police, for investigation. The Supreme Court sat on our petition, finally gave us an SIT after 6 years. But looking at our comparative successes and failures when it comes to minority rights and their protection, it is my considered view, and I'm talking to lawyers here, I'm talking to law students here or lawyers here, so this is meant for academic understanding, not for publication, that Supreme Court found it very difficult to throw out the petitions related to Gujarat because the NHRC report was backing us. If the NHRC report had not been there, it would have been much easier for the higher judiciary to do what they did to the Sri Krishna Commission matters, to do what they did to the Kandamal matters, which is to delay, procrastinate so much that the people fighting lose their steam and lose their enthusiasm. So in that sense, the NHRC report played a pivotal role. In addition to the NHRC report, a Concerned Citizens Tribunal was appointed. A Concerned Citizens Tribunal under Justice Krishna Iyer, Justice P.D. Sawant, 2 judges retired from the Supreme Court of India, and Justice Suresh of the Bombay High Court, and many other people. And this Concerned Citizens Tribunal brought out a 2-volume report in November 2002 And that report is also an extremely important report, because it actually was much more detailed than the NHRC report. It recorded 18,000 testimonies, and most important, it replayed the cynical way in which Godhra, the tragic incident of Godhra, when 58 people were burned alive in the S6 Sabarmati Express, was deliberately misconstrued to spread all over Gujarat. The government, instead of acting firmly at that time, allowed Godhra to be carried to different districts, allowed the bodies to be transported by VHP people, allowed hate speech, gave instructions to police officers not to act. Now, as you go along in your legal profession, you'll probably handle cases of conspiracy. And we are at the moment battling our most important case of criminal conspiracy relating to mass murder in the Zakia Jafri and Citizens for Justice and Peace case in Ahmedabad. 3 days a week we are making our arguments. There are at least 10 articles related to that petition in your package. The importance of Zakia Jafri's petition lies in the fact that we have managed to not just construct a case of conspiracy, abetment to commit mass murder, but we have managed to access investigation documents which run into 40,000 pages for the first time in Indian jurisprudential history. And because of the sheer grit of the victim survivors and a group like ours, we've managed to hang on to the case even when the Supreme Court appointed SIT attempted to give a clean chit. By the way, for your information, accused number 1 in Zakia Jafri's case is Narendra Modi. And there are 59 others who include cabinet ministers, top policemen and top bureaucrats. This case is being heard at this moment of time in the Magistrates Court in Ahmedabad. They are hearing our protest petition. Our protest petition is against the SIT clean chit. And while SIT attempted to give a clean chit, and this SIT was appointed by the Supreme Court, the amicus curiae, Raju Ramachandran, appointed by the same Supreme Court, accepted our view that there was enough evidence to prosecute Modi. And the amicus curiae has said clearly in his report that there is enough evidence to prosecute Modi under certain sections of the IPC. So what do we have? We have a very hilarious situation actually. We have a Supreme Court of India that was approached by us in almost 50 cases related to Gujarat. This is only one of them. And thanks to the NHRC related case, the CJP case, we managed to get SIT appointed. But most importantly, what we managed to get the Supreme Court to do, which it did not do in the 92-93 cases, which it did not do in the Kandhamal cases, is to monitor the trials. Please understand, it was not just the NHRC cases that are, NHRC report that was important, but we convinced the Supreme Court that the FIR was being doctored. What is the FIR? FIR is the first information report of the crime. Powerful accused were named by victims in the FIR. And by the time the FIR actually got registered, the names of powerful accused were dropped. So this caused